So today's speaker is Casey Williams, as I mentioned, partner at Liebert Cassidy Whitmore. Casey has a long background in employment law and is really generous with her time today. So I'd invite Casey to join us, and let's get the show rolling.
All right. Good morning, everybody. Robert, thank you for that wonderful introduction. Thank you all for dropping in the chat where you're coming from and the organizations you're working with. I am, as Robert said, Casey Williams. I'm presenting today from San Francisco as well.
Great.
And I'm a partner with Liebert Cassidy Whitmore. Who is Liebert Cassidy Whitmore, in case you don't already know? We are a California-based law firm. We have offices up and down the state from San Diego to San Francisco and about 100 attorneys. And what makes us unique in the market is that our practice is focused almost exclusively on working with mission-driven clients. That means our clients are either public entities or they're nonprofits. And what do we do for those mission-driven clients? Well, all of us practice some form of employment law. We're employment litigators, we prepare handbooks, we do policies, we help folks day in and day out navigate complex employee relations issues, labor relations issues. And for our nonprofits, we also do work around things like governance, vendor contracts, grant agreements, and also some work around programs, which means we spend time talking with folks about issues related to volunteers, interns, and contractors, bringing us to the topic du jour, right? It's a topic I spend a lot of time chatting about with my clients, and it's a topic that I'm really excited to get to talk about with the Cal nonprofit memberships. It's really a wonderful opportunity. Thank you again, Robert, and thank all of you for being here. A couple housekeeping items to add to Robert's. If you have questions, please drop them in the Q&A box, not the chat box. I'm watching the Q&A box. I'm going to try to take pauses as we go along through our presentation, particularly at the end of each section in my agenda. And then I didn't book anything after this, so I have plenty of time to hang out and answer your questions if you have questions at the end, and you also have some time. If not, you can send me an email. My contact information will be at the end of the presentation and with the slides that you get. All right, so with that housekeeping, let's dive in. On the screen, you should be able to see my agenda here. I've got 3 kind of core topics I want to talk about. The first is basically kind of defining, at least within the eyes of the law, what it means to be a volunteer, or what it means to have an intern, or what it means to hire somebody as an independent contractor versus as an employee. And we start there, and I want to start this morning's presentation there because that's sort of the threshold issue. We spend a lot of time talking about whether volunteers should be paid stipends, as in the question. We spend a lot of time talking about whether they should sign releases or should you have a code of conduct. But before you even get to those questions, it's helpful to understand first if the person has been properly classified. And so that's why I want to start there. Once we have that kind of grounding, then we'll turn to some common legal issues that come up with volunteers, interns, and contractors, including issues related to stipends. We'll talk about things like discrimination and harassment. We'll talk about unique issues related to employees volunteering. And finally, we'll go over some best practices for risk management. And yes, Jennifer, I see in your Q&A, you're hoping that we'll get some questions and answers around stipends and how those work with contractors versus employees, with volunteers. Absolutely, as you can see from the agenda, it's going to be addressed. So let's dive in. Definitions. The point of this part of our presentation is just to give everybody kind of a grounding in what we mean, at least legally, when we talk about volunteers, when we talk about interns, when we talk about contractors. And I wish I could tell you that this was going to be like 3 minutes and then we were going to spend the rest of the time talking about our other topics. In fact, it's going to be what we spend most of the time talking about because it's the hardest part. And it's the part that frankly doesn't have one answer in the law. Instead, there are multiple definitions for volunteers. There's multiple definitions for interns. There's multiple definitions for who qualifies as an independent contractor. Let's start with volunteers as an example. Here on the slide, I have the definition for volunteers as it's defined in the Volunteer Protection Act. This is an act that was passed in 1997 by Congress. It's a federal act. It is not one of our new laws, but we will talk about some new laws impacting volunteers and interns a little later in our presentation. This law, it was passed in the 90s, and what it's intended to do is encourage people to volunteer with nonprofits. And it encourages people to do that by providing them some protection from personal liability. If somebody happens to accidentally be harmed by some decision or action they take in the course and scope of volunteering. Now, I don't want to overstate the level of protection provided by this law. There are a number of exceptions to it. It doesn't apply, for example, to accidents related to driving a car. It doesn't apply to gross negligence or reckless conduct. It's really kind of focused in a narrow kind of area of negligence law. And it doesn't apply if the volunteer is getting any compensation for their services, including in-kind compensation in excess of $500 a year. This is my favorite definition of volunteer because it includes a hard number. Other areas of the law also define volunteer, but we don't get that hard number. For example, the Fair Labor Standards Act, another federal law, has a definition of volunteer. That definition appears in the context of a larger definition of how employees are defined. Why? Because the Fair Labor Standards Act is the federal law that governs wage and hour issues with respect to employees. It requires, for example, that employees who are not otherwise exempt from overtime be paid overtime if they work more than 40 hours in a week. It has certain requirements for meal breaks, and it applies basically to any employer in the United States who's engaged in interstate commerce. And if you're using the internet, you're probably engaged in interstate commerce. So it applies to your nonprofits. Though admittedly, we spend more of our time talking about the labor code and the wage orders here in California because our California laws set an even higher bar when it comes to wage and hour issues. But the Fair Labor Standards Act does apply to employees in California, except if they're volunteers, i.e. they're not actually employees, they're volunteers. And how does the Fair Labor Standards Act define volunteers? Well, we've got it on the slide here. They are persons who receive no compensation, excluding reimbursements for expenses, some reasonable benefits, quote unquote, a nominal fee. And provided, of course, that they're not volunteering to do their own job. That language I find unhelpful, what a nominal fee is. I can tell you that it certainly covers things like reimbursement for actual expenses paid, but what a nominal fee is kind of, it's a little subjective. There is some guidance from the Department of Labor, which is the federal enforcement agency that enforces the Fair Labor Standards Act, that says something like, as long as the nominal fee or the stipend is less than 20% of what you would otherwise pay a person for the work, that's nominal, and therefore they're a volunteer. I get lots of questions about that. I have two kind of core answers I give. One is that is only applicable to issues arising under the FLSA. That rule doesn't apply to California labor laws. It doesn't apply to the Volunteer Protection Act. It doesn't apply to some other areas of law that hinge on whether somebody is a volunteer or not. And those areas of law, I think, tend to take a kind of harder stance on this and really say that a true volunteer is someone who receives no compensation. So the second thing I say is rely on that rule with great caution, because I worry that there are aspects of California law that can come up and bite you if you over-rely on it. For example, there is a law in California within our corporations code. Corporations code governs how nonprofit corporations govern themselves with respect to their boards and their members, and when they have board meetings and how they can set up committees. And one of those laws is Corporations Code Section 5239. Corporations Code Section 5239 is similar to the Volunteer Protection Act in the sense that it is designed to encourage people to volunteer, specifically as a director or an officer on a nonprofit corporation. If you've ever had the pleasure or the honor of serving as a director, you know it's not an easy job. And there are some concerns about personal liability arising from your conduct or your decisions as a director. And so what this statute does is says, if you're doing it on a voluntary basis, you can be protected from some personal liabilities. Provided, again, you're not engaged in tortious conduct, as it doesn't include reckless conduct, you have to be meeting a minimum standard of care, and provided, again, that you're truly volunteering. And volunteering, according to the statute, means providing services without compensation. Compensation is something like a salary or a fee or a payment in exchange for the services. It doesn't include things like a per diem or mileage or actual reimbursements for expenses that are incurred in providing the volunteer services. So you see how that's kind of distinct and different from the DOL's 20% rule. Another place where we see a definition for volunteer is from the Department of Labor Standards Enforcement, which is like the California version of the DOL. We sometimes call it the Labor Commissioner here. And this is the state agency that is responsible for enforcing California's separate and more stringent wage and hour laws. Those laws appear in our labor code and they appear in our wage orders. Though notably, there's actually no statutory definition for volunteer. The Labor Commissioner has taken the position that true volunteers are going to be exempt from things like overtime and minimum wage laws. Why? Because they're not an employee. How is that defined? Volunteer. Well, according to the Labor Code or Labor Commissioner, a volunteer exists if a person intends to volunteer their services for public service, religious, humanitarian objectives, not as an employee and not with the contemplation that they are going to be paid for those services. So, not a single definition for volunteer. I've gone through 4 here. I could do dozens more. What are some key considerations you can take away from this? Some key factors you can kind of determine, okay, I know there's a bunch of different ways this is defined. How can I kind of have some just at least guiding principles? Got a few for you here. One is that the kind of third rail, the biggest issue you're going to run into is if there's some sort of contemplation or receipt of compensation, even in-kind compensation for the services. The real motivating factor for the work needs to be public service, a religious motive, a humanitarian objective. And kind of key indicia that courts and enforcement agencies look for are things like part-time work, or the work is done on a kind of intermittent basis. They're not regularly displacing employees. They're not engaged deeply in your commercial activities. What does that mean? You know, let's say you run a museum and you have a gift shop. Ideally, they're not running the register, your volunteers. They're working instead maybe as docents or running community programs, those aspects that are more deeply connected to the work of the museum as opposed to its charitable activities. And of course, if you have docents, they shouldn't be volunteering to be docents. Now I see a question in the chat to please explain a per diem as it relates to volunteers. A per diem is a set predetermined amount that an individual will be reimbursed for expected expenses that they might incur in the course and scope of providing work to a business or a company or a nonprofit. The IRS actually has guidance setting per diem rates for expected costs for meals, lunch, breakfast, dinner, or expected costs for travel in certain areas. And you can use those to set per diem rates for reimbursing people. It's sort of an option or a way of reimbursing for actual expenses when you can't figure out what those actual expenses are and you want somebody to have the cash in advance. Another question we have in the chat is, how does this apply to many all-volunteer organizations out here? It applies in the same manner as it applies to organizations that have 5 volunteers or 10 volunteers, 1 employee, and everybody else is volunteers. The key thing is that the volunteers, to really truly be volunteering, are not expected to be paid for their work. They may expect to be reimbursed for their work. They may expect to have an annual party at the end of the year where everybody celebrates the hard work of the volunteer-run organization, but they're not economically dependent on their volunteer position for their ability to pay their bills, feed themselves, provide for their basic life necessities, right? So if there's compensation that's serving that purpose, paying the person for their services so that they can then have some of the economic things that they need, that's going to suggest that maybe you don't actually have an all volunteer run organization. You have individuals who may be misclassified as employees. And those are sort of, we'll talk in a few minutes about all the kinds of risks that arise from that. But before that, I do that, I want to talk about interns. Why do I talk about interns in the same context as volunteers? Interns are sort of, the way I conceptualize them often is they are also volunteering their services. They're not doing it for humanitarian or religious or charitable purposes. They're doing it for personal purposes to gain some real life experience, some skills and training that will allow them to then go on and fulfill their own professional or job-related goals, right? But they're not doing that for pay, right? Instead, they're doing it again for the skill, for the training. So they sit somewhere between volunteers and employees. And how can you actually ensure that they're not employees and they are true unpaid interns? Well, in California law, the way you do that is by building out a program that conforms to the 6 factors on our chart here. This is the 6-factor test that is adopted and is still kind of law in California by the labor commissioner. It's a stringent test. It's an inflexible test. You really have to meet all 6. What do all 6 require? The first factor requires there actually be some training to the job, some educational aspects to the job, where you slow down and you teach a person a skill in the same way that they might obtain through a vocational program. The program has to be for their benefit, right? The way I sometimes get clients to think about this is, if you got rid of the internship program, would it harm your operations? Would you no longer be able to do certain kinds of work? If that's the case, it suggests to me that that program is for the nonprofit's benefit, not the intern's benefit. And that those individuals may actually be displacing the work that you would otherwise have a regular employee do. Whereas our third factor on the chart or on the screen says that that can't be the case. And in fact, the interns really need to be a burden. People should be watching them, working with them throughout the day or the shift or the hour that they may be with you, so that you can be giving them that guidance. And in the course of that, you're probably not going to be achieving any immediate advantage. There may be some goodwill. You may generate some loyalty. You may be fulfilling your mission, right? If you have a nonprofit that is focused around, for example, increasing economic opportunities for marginalized populations, you're doing workforce development, certainly there's a benefit in terms of the mission. But there's no immediate benefit in the terms that you're getting work done. Instead, all of the immediate advantage should be for the intern or the trainee. And then there's 2 kind of key pieces to this test, which is that the person can't be entitled to a job at the end, and there should be some explicit understanding about the fact that they will not be paid for their time. I have a question here about how can you locate per diem rates. I would suggest that you Google per diem IRS rates. There's a couple irs.gov websites that you can find those for. If you can't find them, that way you can send me an email and I'll help you that way. Michelle has a question about what the commercial activities are a nonprofit. It is not anything that brings in income. I think when the courts are looking at that test, what they're talking about is something closer to like unrelated income. If you're going to draw from some of the concepts in the Internal Revenue Code related to unrelated business income. And you may be a school, you charge tuition, right? That's a commercial activity, sort of, in the sense that for-profit schools do the same thing, but it's not unrelated to your actual activities. There's a question from Isabel that asks, what do you mean that a docent is paid and is not a volunteer? Can you say more? What I was trying to say there is if you have docents who are paid, they're employees, you're paying them for their time. And you also have docents who volunteer. There are some risks to letting your paid docents, the employees, let's say work 5 days or 4 days out of 5 as employees and then volunteer 1 day as a docent. That is a risky activity because the federal Department of Labor and the California DLSE takes a dim view of that. They question whether that last day is truly voluntary or if somebody is sort of being coerced or pressured into providing free services for their employer. It doesn't mean that an employee can't sometimes volunteer for the nonprofit they work for. But ideally, they're going to be doing that in a kind of completely distinct capacity from their employment work. I have some slides that we'll talk about in a little bit further in the presentation on that. All right, so I want to briefly talk about the Department of Labor's, and this is the Federal Department of Labor's test for interns. It's much easier. It's kind of more flexible. You don't have to meet every one of them. And unfortunately, it hasn't been explicitly adopted in California. So the very cautionary approach I take with this when advising clients is they really should look to the 6-factor California test. But it's helpful to still know about the federal test because I think it has some really instructive aspects to it. There's some similarities, that there should be no expectation of compensation. But they also highlight that to the extent possible, the internship program should be integrated with some sort of formal educational program, some sort of connection to a school where the person is getting units or credits for being an intern at your nonprofit. Or if you have a program where you teach folks and then you send them out into the community and they intern for a business, let's say you do some work around food security and food justice, and you're teaching food skills, food handling skills, and culinary skills to individuals so they can go out and get work in the restaurant industry. And then you have folks intern with a commercial partner. You should be providing them maybe credits or units connected to your certification and training program if they're going to intern with one of your community partners. It's kind of idea. Other key ideas from the federal test are concepts of ensuring that people's internship programs kind of track academic calendars. They have a limited period, right? As opposed to just going on indefinitely. The work, again, shouldn't be displacing employees. And there should be a clear understanding, even under the federal test, that no one is entitled to a job at the end of the internship. Some key considerations to take away. Again, we'll go over and over this. I feel like a broken record. The idea is there shouldn't be any contemplation of compensation for this to be a true unpaid internship. There's a question in the chat that relates to that. Joe, you ask, is a paid internship actually an independent contractor arrangement? My answer to that is probably no. Instead, the answer is you probably have an employee. If you're paying that person to be an intern, they're probably an employee. They don't qualify as a contractor. And we'll talk about that in a second when we go over that test. Though paying them as an employee is one of the ways of reducing some of the risks associated with this kind of stringent test. Because if what this test is primarily about is saying, like, okay, if you meet all of these 6 factors, then you don't have to pay that person a minimum wage. You don't have to pay that person overtime. You don't have to provide them all the other benefits they'd get if they were an employee. And if you're worried you're not going to get that, well, then treat them as an employee. And that addresses the wage and hour risks. It also has some real costs, which I understand is sort of the tension when you guys are trying to develop and figure out how you can achieve your programmatic objectives while also navigating those risks. A couple other key considerations with internships is really to think about how you can tie them either to an external academic institution or to give them, if you're running the programs, some more flavor and indicia of an academic program. So it's not just solely on the job training. There's some sort of lectures or reading or small group discussions where people really learn together. And then the more you can build out the policies and procedures and documentation of the program, the better, with things like applications, enrollment processes, a curriculum for your 6-week internship program. And of course, always think, if we got rid of it, would we be okay operationally? And that's always a good sign that that program is really for the interns' benefit as opposed to the nonprofits. I'm going to turn now to talking a little bit about the definition for contractors, but before that, I'll scroll through the questions to see if there's any more I haven't hit. So we have a question about what are the risks incurred of allowing clients in your programs to volunteer? The risks are a little bit the same and a little bit different. One of the key risks is just the question that we're talking about now, which is, are they properly classified as a volunteer? Often with clients, I sometimes see a real desire to provide stipends or compensations to them for the volunteer activities. And then that drifts into and pushes the relationship closer to an employment relationship. The other issue I see often with clients volunteering relate to things like privacy issues, disciplinary issues, how you navigate if you want, for example, the person to no longer be volunteering because they weren't a right fit for the job or they aren't doing a good job. And so you want to remove them from that aspect, but you don't want it to come back and kind of impact the client relationship. And so we kind of think that operationally, you can have some heightened risks in that situation. I see a question about stipends. I'm going to answer that and discuss it more in detail in a few minutes. And then I also see a question about per diems for unpaid interns. Yes, you can reimburse interns for actual expenses, or you can use a per diem thing as long as the payment is truly for expected expenses associated with interning. And then finally, Bill has a question about many universities requiring student internships to be paid, sometimes a stipend and sometimes an hourly wage. Would the title of that role not be intern? You can give the role any title you want. You can call them an intern. The law, though, may still say that they're actually technically employees because they're being paid for their work and their time and their services. So one of the things that's really important to think about when you're partnering with a university or an educational institution that way, or even a big funder, if you're working with a grantor who says, hey, we want you to pay these interns, is to talk with them about how the liabilities associated with that pay are going to be distributed between you and the university, right? Because you're taking on liabilities by paying them. And so are they going to indemnify you for wage and hour claims if that happens? Or are they going to increase the funding for the position so that you can actually fully fund them as employment positions rather than unpaid internships with stipends? Because as Miguel, I think, I'm sorry, I'm butchering your first name, but as our last question here about whether you can pay someone as a stipend highlights, is that what is a stipend, right? The risk with stipends is that people, I think, often are functionally using them as compensation, paying the person for their time. And what the law says is that paying somebody for their time is what you do for an employee. And so if you're going to pay stipends, there's some risks associated with it. And we'll talk in a few minutes about how you can mitigate those, even if you can't completely eliminate those risks. But before that, I want to briefly go over the definition of contractors, which are also at issue here. So it used to be many years ago that we would all operate under this sort of slightly flexible multi-factor test called the Borello test. And there, if you were trying to figure out if somebody should be classified as an employee or an independent contractor, you'd look at things like who had the right to control the method or manner of their work, who had the right to supply the tools, who had the right to set the pay, was it high skill work, et cetera, et cetera. And then the California Supreme Court issued a case called Dynamax, and the whole legal landscape here changed. Because in Dynamax, the court said, workers who you are paying to provide you services are presumed to be employees. Unless you, employer, including nonprofit employers, can establish three things. One, that the worker is free from the control and direction of the nonprofit. Two, that they're doing work outside the usual course and scope of your business. And three, that they're customarily engaged in an independent, established trade, occupation, or business. And so let's give the example of a community arts center. It has a playhouse that people can rent out. It runs classes in the afternoon for adults learning to paint or to dance. In the summer, there's youth programming. So there's a facility, right? And if that person hires, that nonprofit hires a janitorial company to clean the facilities in the evening, right? And all that's asked is you show up and you clean. You're not telling people when to clean, how to clean, where to clean, what tools to provide. Your art center is not a janitorial company, so that work is outside the course and scope of your business. That janitorial company works with businesses all over the area. They have their own website, they set their own rates, they present you with a contract. That's an independent contractor versus an employee in your facilities department who you say, this is your schedule, this is when you're going to show up, these are your supplies, this is your uniform, this is what needs to be cleaned, when, how, these are the facilities you need to maintain. Maintaining the facilities is part of the work that you do because part of that nonprofit's job is providing a facility for arts and classes and programs. And that person works for nobody else, right? They don't have other people that they're doing this work for. They don't have a business license. They don't have cards. They're not setting their own rates. So that's the distinction that this test is trying to draw and the kind of questions that you would be playing out if you're trying to look about whether this, particularly an individual, is properly classified as an independent contractor or more likely as an employee. There are some exceptions to this test. I don't like using the word exceptions because they would imply that if you fall into them, the person automatically qualifies as an independent contractor. That's not how the exceptions work. The way the exceptions work is that if you fall into one of them, you get to rely on the old Borello test. You still have to establish, even under that test, that somebody is an independent contractor, but they're slightly more flexible. Common exceptions that come into play in the nonprofit sector or professional services. You're hiring a marketing firm, an HR firm, a graphic designer to help you with your annual report, your impact report. As long as there's certain other enumerated things in the statute, like the person has a written contract, they have a business license, they have a separate business address, you might be able to get into those. Same thing with the licensed professionals. You're hiring an architect or an engineer or an accountant, or you're hiring another business to provide you services. You're hiring a law firm, you're hiring an accountant. You can kind of move into those exceptions. And I'm happy to chat with anybody about those in detail. But some key considerations I want you to take away about independent contractors. when you're thinking through those tests and those factors, is that the more control you exercise over the details of the work and how the work is done, the more likely it is you have an employee-employee relationship if you're paying that person for the services. If you're just asking for a deliverable and they go off in their work and they show up, it shows up in your inbox, three weeks later, that's more likely or more closely aligned with a contractor relationship, particularly if that person is working in a distinct occupation or business that's separate from the regular work of the nonprofit. And they're providing their own tools. They're doing it on a short-term or intermittent basis. Intermittent means they may have been your, nonprofit museum has a plumbing company they love working with, and you've been working with them for 20 years. So not a short-term relationship, but you only work with them when you have a problem, i.e. intermittently, right? That's more indicative of a true contractor relationship. And then finally, the relationship as articulated by the parties is important. So as we'll talk about, it's really important to have actual formal written independent contractor agreements if you are using contractors to support your work. All right, before I turn to my next topic, which are the common legal issues, and I'm going to get into the details on the stipend question, I want to check my Q&A box. So I have a question from Sydney, few of them here, about related to the gig economy. I'm not 100% sure I understand the question, but what I think you're kind of suggest is if there's an economic dependence on the stipend by the volunteer or the intern, does that change the nature of the relationship? And absolutely. That economic dependency is what the courts and the enforcement agencies would say is indicative of an employment relationship. A volunteer doesn't need the money. A volunteer is doing the work because they care about your mission. They're doing it for religious or charitable or humanitarian reasons, not because they need a stipend. Another question we have here is, does that mean that you're required to treat interns as employees? No. If you're meeting the 6-factor test for interns, you're not required to pay them. But that 6-factor test, one of the key pieces to it is that there's no contemplation of compensation. So if you pay them a stipend for the work, you're not going to be able to meet the 6-factor test, in which case it may be that you should actually be treating them as employees. Employee versus intern is a legal concept. It's a legal classification. So you can have somebody that is legally an employee and you still call them an intern. You still call them a trainee. But they're paid and they're provided all of the same benefits that an employee would have. In that case, you don't need to worry so much about the 6-factor test. You do have to pay them. You have to take out withholdings. There's some, real cost to it, but it takes away some of the risks. But just providing them a stipend doesn't take away that risks, because you're not going to be necessarily paying them at the minimum wage. You're not going to be paying them meal and rest breaks. You're not going to be providing them all of the protections they would be entitled to as an employee. Couple more questions before we turn to our next topic. Let's see. I think we answered that one. Are independent contractors exclusively 1099s, or if somebody is truly an independent contractor, you document the income paid to them with a 1099. If they are an employee, you document the income paid to them by a W-2. The fact that you have given them a 1099, however, is not controlling in the legal analysis. If you pay somebody and you issue them a 1099, but you're not otherwise meeting the 3 factors here, they're not actually an independent contractor. They're an employee. And the mere fact that they got a 1099 isn't going to be sufficient enough to beat the any potential claims that might arise. And what are those claims? Well, that takes us to our first and probably biggest issue, common issue with volunteers, interns, and independent contractors, is misclassification issues. What do we mean when we say misclassification issue? What we mean is that something happens. Somebody ends up disgruntled, somebody leaves, and there's some sort of lawsuit. And that person who you thought was a volunteer, or that person you thought was an independent contractor, or that person you thought was an unpaid intern comes back and says, no, I was truly an employee. And if they win in that argument, there is a pretty expansive liability associated with that. Because if you're not paying them anything, you probably definitely weren't paying them minimum wage. If you were only paying them a stipend far below the minimum wage, there's still minimum wage liability under federal, state, and local laws. There's also meal and rest break violations. There's all these derivative claims related to wage statements. If you there were requests for leave or things like that, you can run into claims there. If there are audits by the EDD or the IRS for failure to make certain tax withholdings, that can also create liability. So that's why we think it is really important, and why you are all asking such good questions about, okay, well, what if we do pay a stipend or we don't pay a stipend, or how would this impact the analysis? And I encourage you to reach out to your own legal counselor or us if you have those questions so we can help kind of guide you through those. But let's talk about the stipend thing. I promised I would. And clients call, some of you put questions about how you deal with a stipend. The reality is, and it's not a satisfying answer, is that I tell people not to do it. They get to decide what they're going to do. It's not per se unlawful to pay an unpaid intern a stipend or to pay a volunteer a stipend. But by doing so, it muddies the water and it creates a factor that they can point to say, actually, I wasn't really a volunteer. I was doing this for a stipend. And I always had a contemplation that I was going to be paid for my time or my services. In response, some clients say, look, we can't fulfill our mission without providing the stipend. Or we have third-party partners, universities or funders that require a stipend. In which case, we talk through some ways of potentially mitigating those risks. One of them, as we've already been talking about, is to pay the person as an employee. Just treat them as a paid intern or hire them as a paid docent. Another is to, rather than pay them a stipend, is to reimburse them for the actual expenses that they incur, or to use a per diem to do the same thing. You can also go back to some of those funders and donors and talk about, hey, rather than us paying the stipend, is it possible for you to provide a small grants program or a scholarship program where people are paid for their time by a funder to come complete a program at our nonprofit? To think a little bit outside the box in achieving the goals of both the funder and the nonprofit, while mitigating against some of the risks that council's raising. And the last is, if you're going to pay a stipend anyways, at least tie it to something other than the performance of the services. Don't tie it to hours worked. Don't tie it to productivity. Why? Because that's what we pay employees for. We pay them for their time. We pay them for their productivity. Try to at least tie it to something like, hey, if you're going to have to travel halfway across Los Angeles County to participate at our research center along the coast, we're going to pay you for those estimated costs. If you're going to have to get meals, we're going to pay you for those estimated costs. If it's going to require you to buy books or tools, we're going to pay you for those estimated costs. It's pretty close to a per diem. It's pretty close to just reimbursing, but at least it's not tied fundamentally to time or to meals. And then document somewhere that this is unpaid work, or that this is not compensation for work. All right, I'm happy to hang out at the end and talk more about some of these stipend-related issues. I want to talk about some other legal issues that come up with the misclassification ones. First is the harassment and discrimination issue. If you take away nothing else from this training, if you didn't already know it, I want you to know that under California law, under the Fair Employment Housing Act, volunteers and unpaid interns are protected from harassment. And in fact, so are contractors. This is explicitly stated. What that means is your volunteers, your interns, and your contractors can't harass your employees, and they can't harass, or you can't harass them, right? On the basis of things like gender, national origin, sexual harassment, their race, their ethnicity. questions I get then. Okay, well then do we have to be training them as well, just like we have to train our employees? No. The California Department of Civil Rights, used to be known as the Department of Fair Employment and Housing, says, no, you don't have to train those individuals the same way you might train employees. But you do have to ensure that your policies cover them and that you train your employees on not harassing your interns or volunteers or contractors. And if you are one of those, by the way, organizations, there was a question about what if we're a completely volunteer-run nonprofit? You should know that the Department of Labor Standards Enforcement says volunteers count for determining whether or not you're required to train employees. So let's say maybe you actually have 2 employees instead of 5, and everybody else is volunteers. In that case, you should be training those 2 employees. And you might want to consider, even if it's not legally required, training your volunteers as well, especially if they are ongoing big part of your operations. The next question I get here is, okay, well, what happens if they harass or discriminate or excuse me, harass each other, or we run into problems? How do we address that? With an employee, we fire them. But what do we do with a volunteer? What do we do with an intern? The law requires that you take reasonable steps to correct that action. So if you don't fire them or you don't write them up because they're not an employee, you can certainly say to a volunteer, you're no longer welcome to volunteer here. We're no longer going to allow you to participate in our internship program. You can call up the actual employer of the contractor and say, we have some concerns about the way your contractor has been treating or way your employee has been treating our employees. We would like you to assign somebody else. Right? Common sense, practical measures can absolutely be taken. If you happen to have existing policies and procedures like codes of conduct or rules around how certain volunteers or interns can or cannot act, then enforce those rules. If you don't, and you're worried about these issues, it's a really wonderful opportunity to adopt codes of conduct, volunteer training programs, even volunteer handbooks we have. And when we help clients with those, we include a harassment prevention policy in them. Other common legal issues that come up with volunteers and interns. We've talked about this one a little already, which is just employees volunteering in their own job. It's generally not okay. Here's a hypothetical to kind of give that a sense, right? We've got Mr. Jones. He's a PE teacher at a private nonprofit school. He has a son on a tennis team. Can he volunteer to coach his own son's tennis team? I would suggest to that client that that's kind of risky because it's sort of in the same vein of his own job. And it raises a question about whether he's truly doing it on a voluntary basis. As opposed to, let's say, Mr. Jones hypothetically works at a cancer research center. And each year that center hosts an annual fundraising marathon. And Mr. Jones wants to volunteer at a water station. Can he do that? Yeah, that's less risky. It's pretty outside the course and scope of his day-to-day job. So it suggests that it's more truly voluntary. Let's say Mr. Jones is on events. He's in the development department. Running this activity is literally in the course and scope of his job. Maybe not. Then I would be more concerned about the idea that he was volunteering. Another kind of related issue that comes up here is with directors. Oftentimes I see, well, often might be an oversight, but every once in a while I see directors who receive some sort of benefit for their services. Let's say they get a discount on registration. This comes up sometimes with youth sports organizations. Their revenue stream is families pay for kids to play every year. Let's say registration on the club soccer team is $1,000 for the year. And directors get that waived as a courtesy. If you've got 4 kids in the program, that's a pretty big courtesy. And in fact, I think it veers into a space where one could see that as compensation. And that raises a whole host of issues related to misclassification issues, including issues related to those protective laws that we talked about at the start of our hour, right? Volunteers get certain protections from the law. And if your systems are kind of blurring that line, whether it's through stipends or discounts to directors, it could impair their ability to take advantage of those in a difficult situation. All right. My last slide is really more of a transitionary side to the biggest kind of legal issue outside of misclassification issues that come up, which is liability either for harm done to a volunteer or intern or contractor because they get injured at your facilities, there's a slip and fall incident, etc., or vicarious liability associated with the actions of your volunteers, your interns, or contractors. They hurt somebody else in the course and scope of their work. And what's the liability for the organization? Are they going to face a claim for negligent hiring, saying you should have known, or you did know this person was unfit for the job, or you didn't closely supervise them? You're negligent in your supervision of them. Those are the kind of liabilities that should play out in the back of your mind when you're thinking about risk mitigation measures to adopt with respect to volunteers, interns, and contractors in your nonprofit workplaces. What are some of those? Can you get insurance to cover those risks? Are there agreements you can adopt? What can you do in your programs? A lot of things. For example, with workers' comp, there is actually a process under the California Labor Code, Section 3363.6, that allows nonprofits to cover volunteers under their workers' comp policy, which may be a way of mitigating some of the risks, particularly if your activities at your nonprofit are high risk and you want to ensure that if volunteers are harmed, that harm is going to be dealt through the workers' comp system. It requires a board declaration. You should talk to your brokers about the costs. You should talk to your brokers about the premium impacts. You should talk to your brokers about how to actually move through with that process. And when you do, make sure to talk with them about other types of policies and insurance that's available. There's volunteer accident insurance, which is sort of a secondary policy that might provide some protection and benefits to your volunteers who are injured. It also might provide you a pocket of money to help pay for those kinds of claims. Another thing to do with that broker is just to really make sure they understand how your volunteer programs, your internship programs work so that they can provide you guidance on whether you're properly insured, both in terms of policies and in terms of limits. Right? Written agreements. What do I mean by written agreements? Written agreements, literally a piece of paper that the intern or the volunteer, and sometimes the contractor, signs. With volunteers and interns, key things that should be in that kind of agreement is a confirmation that the person understands they're not an employee, confirmation that they understand they're not going to get paid. If you're going to require them to do a criminal background check because they work for minors, confirmation that they understand they have to pass that, right? Confirmation that they're going to follow your codes and your policies and your rules. And importantly, that if they don't, or frankly, even if they do, that you as a nonprofit organization retain the right to decide who and who will not volunteer or intern with your organization. Other things covered in an agreement like this relate to workers' comp and kind of just solidifying that there's no expectation that they might have a job at the end of their volunteer or internship service. Usually you're going to include a general release in a question like this, but I want to flag if you have especially risky volunteer activities, you might want to have that release as a standalone separate document that really goes into the details about the kinds of risks associated with your volunteer activities. All right, background checks. Here's my new law, newish. For a very long time, nonprofits that have volunteers working with youth have been entitled to have those volunteers preemptively background checked and screened basically for convictions related to sex offenses, certain violence offenses, certain types of drug offenses. Since 2002, it has now been required that volunteers, regular volunteers, and administrators and employees at youth organizations be screened. What is a youth organization? It's sort of a circular definition, but it is somebody who works for a youth services organization. So this is going to be after school providers. This is going to be youth sports organizations. This is going to be church groups associated. This is going to be scouts. This is going to be youth mentorship programs, all covered under AB5. And so if you're not aware of it, feel free to reach out to me. It requires screening. It requires training on mandated reporting. And it also requires that you implement certain systems, like a system for ensuring that no more than, or that there are always basically 2 adults with minors at the same time. As you implement those sorts of systems, and even if you don't work with minors, kind of key things to think about in terms of mitigating risks is just to adopt the same policies and procedures that you adopt in other areas of your operations, right? We all have employee handbooks. Volunteer handbooks can be an excellent way of setting expectations, creating a code of conduct, as can developing systems for applications, screening people, and training people in ways that set expectations so that they do their work more safely, and so that you set expectations should you ever need to defend yourself in terms of whether or not you had appropriate levels of supervision and oversight into the work that your volunteers and interns were doing. All right, so that's everything. I know I have a whole bunch of questions. Like I said, I'll hang out, I'll answer questions. Couple key takeaways on my slide here. We've already talked a lot about the compensation issue, and I know it's a hard one. I'm happy to keep chatting about it. But my last few takeaways on just how to navigate these issues are to have written volunteer agreements, have policies and procedures in place so that you're setting those expectations, including with respect to things like unlawful harassment, including with respect to things like supervising and screening, and then to actually implement those at your nonprofits. And finally, talk to your insurance brokers about making sure that you're also well covered for any claims that might still arise. I have my contact information here. You'll definitely get it in the slides when they're distributed by Cal Nonprofits. And before going through some of the questions for a little while now, I'm going to turn it back over to Robert.
Thank you so much, Casey. This was just an incredible webinar. Such great content covered. And I know there are still some questions around some of these confusing issues. And so we really appreciate you extending your time with us to address some of those questions. But I really do want to underscore, of all of the webinars that I have been involved with discussing these confusing topics, I think this one is by far the most clearly presented. So I just want to thank you for breaking down and addressing the different areas and issues that we all find ourselves struggling with. So thanks again, and I'll let you dive into these questions and let me know if I can help address some of those.
Yeah. So I think I'm on a question about, we have a nonprofit student housing cooperative, and your tenants are members, and we need their labor in order to manage the house and operate the nonprofit. Okay. We used to give rent credits, right? But then we stopped because California law. Okay. Can we give rent credits to volunteers? Their labor is essential to the management of the house they live in, and essential to the operation of. They should never qualify because they only provide labor to our. Yeah, I definitely agree with you that these individuals probably do not qualify as independent contractors, right? I think this is probably a question that's a little bit too nuanced to answer in this format, because I don't have a good handle on how landlord-tenant laws come into play on rent credits. But I can say that you're asking the right questions, you're thinking about the right issues, which is that there is some sort of in-kind compensation that's happening for these services, and how you kind of navigate that within the structure of your nonprofit housing cooperative is important to understand legally. I think that there is an organization called the, I think it's the Nonprofit Sustainability Cooperative that does a lot of work around this issue. And if you email me, I'd be happy to give you their information. They might be able to guide you to some more specific answers to this question. All right, we've got another question that asks, can an employer who needs extra help recruiting hire a contractor to supplement recruiting efforts? The contractor would provide recruitment services, as would the recruiting employees. Potentially, yeah, you can hire as a contractor people that are going to help on short-term basis with operational needs. So often, for example, you might hire a third-party accounting firm sometimes to help you navigate a really complex audit, or you're behind on some rules, and so you want, literally, there's a company called part-time controller, so you might hire to help you with those services. The question is whether it's structured in a true independent contractor relationship. So things that I would want to know is, does this recruiter have a business license? Is this recruiter setting their own rates? Is this recruiter advertising on Yelp or otherwise? Do they operate through an LLC? All of those are factors that would suggest that you're going to have a better time fitting in to one of the independent contractor exceptions to AB5, the ABC test, which is that professional services exemption. HR professionals are one of the professions listed there. But you've just got to meet all of the other requirements under that test. So if you're not controlling the method and manner that they're doing their work, they're really in their own business, they are charging their own rates, those would all be helpful factors there. All right, so I have another question. Does it help mitigate the risk if we label it an educational stipend? Maybe nominally. I mean, I think that's closer to something like a scholarship, right? You're providing somebody a scholarship to participate in your training program. But it doesn't completely eliminate the risk. And I don't want to overstate how much I think names, I think they're important. How you label things, absolutely important. But there's still just an inherent risk to the payment because of the definitions we went over at the beginning. How can you help mitigate a little bit? I mean, thinking creatively about what it is, how you're labeling the stipend, what the payment is for, but also some of those things that we talked about in terms of an actual agreement, memorializing what the stipend's for, confirming the person knows they're not an employee, etc. All right, what do we have next? Let's see. I think we have a question here. What category do paid training participants fall under? They are not employees, but receive a stipend for attending a training and weekend event. Well, that would depend on sort of the kind of the factors that we've talked about. And I would be concerned about the stipend paying somebody for their time to attend something, right? It's the absolute controlling factor. The mere fact that you pay them a stipend absolutely means they're employees and they're misclassified. No, but again, if you look at all of the tests that we talked about, the key piece there was, is there a contemplation of compensation? So if the way you're promoting that program is come to our one-day training event, receive a $500 stipend, right? That person who signs up has probably got a clear expectation that what they're doing, they're going to give you some time, they're going to sit in your training thing, and they're going to be paid. And then I would be worried that it's not really a volunteer thing. Now, what's the exposure there? If it's a one-time thing and they're there for less than 2 hours, like it might be a little, you're not really worried about overtime unless you've been doing it for 4 years and it's 600 people, right? So you'd have to kind of play out for yourself when you're thinking and doing the cost benefit analysis of structuring these programs, those kinds of issues. All right, so now we've got, if the stipend is paid to reimburse for reasonable expenses incurred by an intern to be W-2 or 1099, how do we handle the payment? So if it's a true reimbursement for expenses, that's not taxable income. And so you should talk to your accounting about that. But if you're doing it according to a true accountable plan, then there shouldn't be a need to provide them a 1099 or a W-2 because you're reimbursing them for expenses, right? So again, talk to your accountant about that, but that's the idea behind reimbursements for expenses. No one's incurred any income. They've lost their own money to pay to volunteer for you, and you are reimbursing them for that loss. All right. Next, we've got, was the prohibition against pressuring employees to volunteer California law or federal law? It's technically explicitly stated in the Federal Fair Labor Standards Act's regulations. They say an employee cannot volunteer for their own employer doing their same job. But it's an idea that runs through California law and frankly the common law, the judge-made law, that the concern when people are volunteering to do their own job is that that's not really volunteering. There's something inherently coercive about somebody day one being paid for a service and day two volunteering for that service. So this way we always recommend that you kind of tread very lightly in those scenarios. If you are going to allow it, it's the kind of scenario where you really are going to want to have very clear written communications to your employees that they are not required to volunteer, that they are doing that wholly on their own time, that they're not going to be paid, that they're not going to be covered by workers' comp, et cetera, et cetera. All right, next question. If you have a high school age student under 18 volunteering with youth, do they also need to pass the background check? I think this is in the context of AB 506, which I talked about this one here. AB 506 does not require regular volunteers under the age of 18 to be background checked. If they are over the age of 18, they need to be background checked. There are kind of other issues, though, that come up with volunteers and minors, right? I think the misclassification issues are even more risky because you have different kinds of laws with respect to employing minors. You've got issues with respect to work permits. There's certain hours they can work. There's limitations on what days of the week they can work, depending on their age. And then there's just other issues around parental consent, right? Particularly the younger the volunteers may be. All right, next question. We've got, can an employer who needs extra help recruiting, oh, we did that one. How about, for independent contractors who interact with employees as part of their scope of work, does it make sense to share anti-harassment policies at the org? Or does that cross boundaries between contractor and employee? It's an excellent question. So imagine you've hired a company and they assign an employee to your nonprofit to come. Let's say you guys are doing a new software implementation system, and on site, you've got a trainer who's going to be there for a week and train folks on how to use a new database system. Should that person be trained on your harassment policies? I would say no. They should be being trained by their own employer, right? If issues run in, you have issues with that person on your site behaving unprofessionally, that's a call to the software company and say, hey, your person is causing some problems. Can you assign somebody else? But contrast that with, let's say you've hired a company to come in and they're going to be doing some consulting and business work for you, and they're going to have a person on site for months and months, day in and day out. In that case, maybe you might want to have that independent contractor sit in on your training and get up to date on what your policies and procedures are so that you know that you've informed them on your conduct expectations, and then also know if they ever have any issues, who to report their concerns to. This is really going to be fact specific and depend on the individual and the contracting relationship and the services you're getting. All right, next question. All right, we're a membership organization. We often will pay the membership fee for some volunteers based on their level of engagement. Does this pose a risk to our organization? This is interesting. I'm going to assume that this means that this doesn't mean like a statutory member, like a person who can vote under your bylaws. But instead, it means you allow functionally someone to pay their membership fee through in-kind services. I think that it presents kind of the same risks. Like the same issue spotting should be happening and you're doing it. I do think that it is a little bit safer in the sense that, you can kind of clearly articulate what the payment is for, right? Or what the services are for, as opposed to just a random stipend that says, come volunteer with us and we'll give you $500 for a stipend, or $700 for a stipend, or $1,000 for the summer, right? Here you're saying, come be a member of our organization, and here's how you can pay your membership fees. You can do work, you can pay a fee, right? So it's a little distinct. It is, you do want to kind of look at the whole, facts and circumstances to be sure, but I think that distinction is notable. All right, next question. Somebody says, we are not a youth service organizations. Most services and programs are for adults, but we do have youth programs as part of our offering. Does AB 506 apply to that one program? I don't know. I think you would want to analyze whether or not you're a youth service program if you're providing programming to youth. I can tell you what AB 506 is about. AB 506 is about the largest settlement for sex abuse, historical sex abuse claims in the history of our country related to the Boy Scouts. It's a specific statutory response that is designed to encourage organizations working with youth to implement systems to protect children. So my thinking on that is, like, if you have any question about whether or not you're a youth service organization and you're providing services to youth, even if you also provide services to adults, say, for example, you're a house of worship, I would lean on assuming that you're covered, because what you're assuming, your assumption is designed to protect children, right? And you already are, as a nonprofit organization, permitted under this statute to require those individuals to be background checked. So, I mean, you might as well just cover your bases by getting it done. All right. We have question: if the individual is an employee but wants to volunteer to start a program that the organization does not have funds for, like the case of the teacher of the school volunteers, does that mitigate the risk? Maybe. I'm still always concerned about employees volunteering in that way too, right? Particularly because that hypo suggests that if you had the funds, the person would be paid for that work. Um, I don't know enough about the individual organization and all the details, but those are the kind of like concerns that I have around that, is that it's work you'd otherwise be paying for, including that person. So it'd be something that I'd want to evaluate, and you'd want to kind of evaluate the risks and cons and your risk tolerance level in allowing something like that to happen. All right. We would like to have somebody do clerk work of specific types for approximately 5 hours per week. Does that fall under employment agreement? I'm not 100% sure I understand the question. But what I can say is that the number of hours a person is working, like, basically, if you're only volunteering for 3 hours, but you're otherwise, getting a stipend, and you're not doing it out of the, goodness of your heart, you're doing it for the compensation, even though it's only 3 hours, still presents a risk, right? The fact that it may be small isn't really the key consideration in terms of time. It's the fact that the person is doing the work for money that is the key consideration. All right. Let's see, how about, are there any templates that can be shared to structure a compliant volunteer program? I don't have any templates that I can kind of provide for that. I know there's lots of templates out there for things like volunteer agreements, getting yourself started on a volunteer handbook, putting together things like a code of conduct. I can't imagine how nonprofits doesn't have some resources they can point to you for things like that.
I was
So
just going to
definitely,
chime in
yeah,
and add to that. I think the answer there is to really have a robust volunteer handbook.
yeah. And there's templates that can get you started, but you need to refine them for your work and the program that you have.
I'll be sure to include the resources that we have on our end in the follow-up email.
Cool. All
Yeah.
right, so let's see, what do we have? If we want to hire someone to help with an admin task, can it be a contractor or employee? Well, I hate to give you the lawyerly response to that question, but it depends. It depends on what an admin task is. It depends on whether or not you're going to control the method and manner in which they work, whether that admin task is central to your business, and whether that person is in their own independent um, occupation business, right? You've got to look at those ABC factors and see how they play into that analysis. Okay, we've got a question from Theater Bay Area. We use grant panelists that we pay. We are still offering the same stipends we gave before AB5. They read and score the applications on their own, but they are required to attend 2 meetings. Grant making is part of our core work. There are peer panels serving on grant panels. Isn't that usual work? I have seen organizations call their grant panelists volunteers and then calling the stipends as honorariums and support or underwriting their time. This seems fishy. Are they all actually temporary employees? I think these are all really wonderful questions. And your question highlights I think the pretty far sweeping implications of AB5. And one of the wonderful things about Cal nonprofits, frankly, is that they're serving for you as this, statewide association that's looking out for how coming pending policy and legislation is going to have unintended impacts on the nonprofit sector. And this example really highlights, I think, how AB5 really did have some kind of surprising and unintended impacts. Because I think a lot of people thought that kind of work, well, they're probably just contractors, right? Like I'm not controlling how they review the grant application. We're not telling them other than to show up at this 2-hour training when and where to do it. Yes, it's connected to our work, but it's not like it's ancillary, right? And now that's become much harder. And we're having to deal with these harder questions. So I can't tell you whether they're independent contractors or not, but I can tell you it's a hard question. And that I'm happy to chat with you about the details and offline.
Thanks for bringing up AB5. That's been a real concern in our sector.
Yeah, and we've gotten, I know you guys have done good work on little changes, but it really, yeah, I think the intent was great, but it had some pretty significant implications for the sector. All right, last 2 questions. We have, what about a ED that has 2 nonprofits and paying from, okay, wait, hold on. What about an ED that has 2 nonprofits and paying from one nonprofit that demands that you volunteer to the other to do the same work? I don't know that I can pass on the details of this question. It gives me some concern. I'd need to know a little bit more about the details of what's happening there. But yeah, the idea behind voluntary is that it is genuinely voluntary, that if somebody is doing it because they want to give back to their community, they care about the mission, it's kind of tied to their sort of humanitarian or charitable endeavors. All right, last question. How do you advise boards that want to provide financial support for board members to participate as recruitment strategies beyond reimbursing expenses? It's a really hard question. I get this a lot in youth organizations. I get this a lot in schools. I get this a lot in Head Start programs where there's a real desire to have parents on the board to bring that representation, but an acknowledgement that it's taking away time and creating costs for them. Sadly, it's the same analysis though, right? You're going to have to talk about, the fact that compensation blurs, makes things a little blurry about whether or not they're really volunteering. And I think it's important for those volunteer directors to understand that. Think about what that means in terms of their ability to take advantage of some of these protective statutes. Think about what that means for the organization in terms of some employment issues. And then think really about how much, right? Because there's another kind of issue we haven't talked about, but with respect to directors, they stand to influence the organization. They have a lot of power. And so whenever you have insiders that are making any decisions, frankly, with respect to their own compensation or being paid, your executives, your directors, you have to really make sure that compensation is fair and reasonable. And so you'd really want to analyze that in addition to all of the other issues we've talked about this morning. All right, I think that's everything. Anything
Casey,
else, Robert?
no, we've covered such a breadth of ground here, and I want to note that we've answered almost 45 questions. So thank you for being so generous with your time. I also wanted to underscore everyone will be receiving a recording of this webinar. And in the webinar with the slides, we have Casey's contact information, and she's made herself available to you. So it's just wonderful for you to have joined us today and shared your expertise with our community. I can't thank you enough, and I wish we could all give you a round of applause um, for the time you took and the way that you really broke down all these different parameters, laws, regulations, and address some of these confusing and specific questions.
Yeah, I'm super happy to. I care deeply about this sector and the work that all of you are doing. So I do not mind at all sharing some time. And and thank you too also for the opportunity. Cal Nonprofits is doing some great work. So you all are working with a great organization today.
Thanks so much for saying that, Casey. And thanks for everyone for attending. We look forward to hosting you and having you at some future Cal Nonprofits events. Everyone have a great afternoon. Take care. Bye now.